Welcome to the Progress Texas Happy Hour.
Welcome back to the Progress Texas Happy Hour. I'm Executive Director Kathleen Thompson.
And I'm Digital Associate Haley Smith.
The fight for reproductive justice in Texas is daunting, to say the least, with no light at the end of the tunnel for now, for those of us who wish to restore access to abortion health care. Here in Texas, a secondary goal line has been established, and that's the preservation of the very health of Texas mothers. With our state's ham-fisted abortion bans frightening doctors out of opting for abortion care even when it's medically necessary, several Texas women have senselessly lost their lives, and many others have suffered from sepsis and other complications that, in the context of hopeless pregnancies, simply didn't have to happen, rendering already heartbreaking situations into life-threatening traumas.
Following the brave efforts of some of these same women, including Amanda Zurawski and Kate Cox, who have converted their personal stories of anguish into very public campaigns for change in Texas, advocates for safety in maternal medicine have seen SB 31, dubbed the Life of the Mother Act, as an opportunity for bipartisan cooperation in further clarifying what doctors can and can't do for their patients.
Advocates for the full restoration of reproductive autonomy see it as falling well short of that goal, which of course it does. SB 31 doesn't in any way relax the ban on abortion in Texas, and others have warned that within its language lies the potential of an entrenchment of that ban, as well as expansion of related prosecutorial options, perhaps expanding that legal jeopardy to Texas women who have sought abortion care in other states.
We needed an expert close to this bill to fill us in, and the first person who came to mind was Austin State Representative Donna Howard, a trained nurse herself and one of our state's longest-serving and most dedicated champions of the rights of women and pregnant people in Texas. To share her view of SB 31 and its House companion, of which Rep. Howard is an author, Representative Donna Howard. Welcome back to the pod.
Thank y'all so much for having me.
Here at Progress Texas, we've been optimistic about the possibility that this bill could accomplish at the Capitol what Amanda Zurawski and her fellow plaintiffs tried to accomplish in the courts. Let's start with the positives, Rep. Howard. What would SB 31 clarify for doctors in Texas?
Yeah, SB 31 and HB 44 are medical exception bills for medical emergencies. They are not choice bills. We are not talking about choice, unfortunately. I definitely want to go there. We will continue to fight for choice legislation, but that's not what this bill is. This bill is specifically providing the opportunity for physicians to be able to practice evidence-based medicine using their reasonable medical judgment and actually intervening with medical complications that currently they are threatened and not intervening. And we have seen the horrific consequences of that in terms of Texas moms actually dying, preventable deaths. They're actually dying, as well as many women who have ended up having medical complications that through sepsis and whatever else that have rendered them infertile. It's just horrific what has gone on. We are losing doctors who are leaving our state. We have residents who are not coming to our state. It has tremendous ripple effects. So this is a bill about medicine, about medical practice, about allowing physicians to practice medicine. It has nothing to do with choice. And I know that that is difficult for a lot of us who really want to be working to make sure that we are passing bills for choice. But right now, we don't have the votes for that at the Capitol. And we're going to still keep fighting for it. But until we get a change in those that are elected to serve here, we're not going to be able to get that accomplished. What we can get accomplished, what we do have control over right now, is ensuring that we protect the lives of Texas moms. And that's what this bill is about.
Tell us what's in this bill that people who are enthusiastic, and rightfully so, about its benefits for expectant mothers in Texas might be missing. Republican Senator Brandon Hughes told the press that, quote, "there's no opposition," unquote, in the ledge. Do you agree with that? And if not, what's the catch?
You know, this bill was drafted by some lawyers who actually share our commitment to access to abortion health care. It was drafted, though, in a way that those who are so-called pro-life would not oppose it. That's why it does not touch choice at all. It does not touch elective abortion options. It's really been drafted to very carefully say that doctors can practice evidence-based medicine, use their sound medical judgment, and make the decision that there is potential for harming major bodily functions, that there is the potential for death. Does not have to be imminent. It does not have to be happening right now. We're talking about a wider definition of when a physician can intervene. It removes the criminal and civil penalties, so doctors are no longer threatened and can actually practice. So that means you can go to any hospital, any doctor's office, and they can make the medical judgment and intervene and provide the abortion if it meets those criteria in their medical opinion. The onus of challenging that is on the state. It's no longer on the physician to defend themselves. So it gives much greater latitude and ability to our physicians to actually practice medicine, to maintain the doctor-patient relationship, and to save the lives of Texas moms.
Rep. Howard, will you give us some more specifics in the bill? I read the bill a couple times preparing for this interview, and there are specific examples, not just vague language. Could you talk about the specifics from the perspective of a doctor, specifically ectopic pregnancies and other instances where a doctor is freed to practice healthcare for their patient who needs it?
Yeah, this is part of this is just clarification of what already exists. And, the difficulty here is physicians don't always read all the laws. They don't know what the laws say and when things are changed. So there has been a lot of misunderstanding, a lot of not really knowing what is in the current statute. What this bill has, I think, to what you're referring to here, is it refers to a couple of different situations that are already in current law, and it just reiterates that. So in 2017, the legislature passed legislation that determined that ectopic pregnancies were not quote unquote abortions if they were terminated. The fact is that any termination is an abortion.
It is an abortion.
Yes.
Yeah.
Yes. There are some who get hung up on the word because the word has been stigmatized. But in fact, that's a common procedure for an ectopic pregnancy, which can be deadly to a woman if that pregnancy is not terminated. We had the chair of state affairs at the time, who was self-identified pro-life, who had come off of a very strenuous campaign where campaign literature indicated that his wife had had an abortion because she'd had an ectopic pregnancy that was terminated. And he was horrified. And in his powerful position that he had, he got this legislation passed that said, oh, no, ectopic pregnancy termination is not an abortion, which is contrary to what a medical understanding might be. It's also in statute that an abortion, there's an exception to the abortion restrictions if you are removing a dead fetus, so a miscarriage. There are some that don't understand that either. So if this is what you're alluding to, there is some specificity given, but it's actually not a laundry list of the ways you can do it. It's left up to the doctor. So we're not creating a list of when you can and can't do it so much as saying there are a couple of things that are already in statute and clarifying that. But indeed, it's a very general, broad definition that indicates when the doctor determines in his or her reasonable medical judgment that if this pregnancy is continued, for whatever reason, the woman could have irreparable major bodily function damage or could actually die, then that physician may do an abortion. And it's not up to the physician to justify it. It's up to the state to prove that something was wrong, which is a high hurdle to cross.
Thank you for saying what is and isn't an abortion. I think that too often people just don't understand because it's not talked about.
Right.
And that's why we are in the place that we are now, because people really don't understand how women's bodies work and don't understand medical terminology. as it is. I do have one more follow-up about the specific language. Near the end of the bill, there's information about educating attorneys, but also educating obstetrics doctors, and it's mandatory. And it says that it's going to be a one-time mandatory training. Could you say a little bit more about how that education program would work and who'd be putting that together for the doctors so that actual medically correct language is what doctors are getting and not politicized?
Yes. I can tell you that the continuing legal and continuing medical education would be provided by those who have helped draft this legislation and who are looking at it being medically accurate. There could be others that will attempt to do the same thing. That's always the possibility. But I think that what's going to happen is that the medical community, the obstetricians and gynecologists, their organization, Texas Medical Association, they're going to look to the language that is going to be informative and give doctors the information they need to practice medicine. So I'm confident that we're going to have something that's medically accurate, knowing that there's always the possibility that someone will take advantage of any situation.
Yes.
But we do have plans in place in anticipation of having medically accurate information shared.
This, like you mentioned, is not a pro-choice bill, but you are obviously a champion of pro-choice values. So I was curious, how did you become an author on this bill? Was it brought to you before the session?
You know, we have talked about this over the past couple of years. Last session, Representative Ann Johnson from Houston had House Bill 3058, which provided some affirmative defense for ectopic pregnancies and premature rupture of membranes. Again, this was done kind of behind the scenes. It was done to protect the doctor. She represents the medical center in Houston. That's a huge outfit. And this was done to give the doctors protection. At that time, that was kind of like thought of as a first step, knowing that it wasn't really going to help it. Because that's after you've actually been brought into the legal system. You know, it still would give them something, but it wasn't going to change their behavior and give them protection to do that. So there was always the concept that we were going to try to move on to something that would actually give the doctors the protection that they needed. That was just kind of a first step. So it's something that we've all kind of been talking about off and on for the past couple of years. I wasn't directly involved in the drafting of the legislation, and neither was Ann, actually. This was drafted by some attorneys who represent the Medical Association, the obstetricians and gynecologists, some lawyer groups that are actively trying to see this exception be put in place. So it was really drafted by some attorneys who know this system and how it works here and wanted to make it as tight as possible so that it couldn't be used to justify anything other than what we're trying to accomplish here. So I didn't actually see the language itself until everybody else did. When it came out, the very final moment at the filing deadline. That's when I first saw it, and have had multiple meetings with lawyers and advocacy groups since then, looking at it from a variety of perspectives. But I am still 100% behind doing this because I believe it accomplishes what we need to accomplish in the short term while we continue to work on those things we're trying to change in the long term. And I do not believe, from what I have read and from what I have been, I'm not a lawyer, but from the lawyers that I have been talking with, that this gives any more credibility to the 1925 law than already exists. Senate Bill 8, the one that started us on the path of not having access to abortion health care, it references the legitimacy of the 1925 law in that statute. There's already statutes that are mentioning this. So what we have done in this bill is changed the definitions of when medical doctors can intervene so that it's consistent across the 4 different statutes that are still currently on the books. That was determined to be the fail-safe way to make sure that doctors would not be threatened if any of the statutes still provided penalties for doctors. Then we still had the possibility of not changing the behavior because of the threat. So that was how this was determined. And I realize that there is some differing opinion here. But again, as much as I don't want to see this get used in any way to increase litigation against people who are seeking the kind of health care that they need to seek, funders who are trying to help them cross state lines to get the health care that they need, I also am having to fall back on what I have control over right now. Those are hypotheticals that could occur. What I do know for a fact is that we will change the behavior of doctors. They will be able to intervene with many Texas women, and that we will actually save the lives of Texas moms.
Rep. Howard, you're addressing some of the concerns that have been raised nationwide. Esteemed national abortion rights writer Jessica Valenti has a ominous blog out this week titled "Urgent: The Texas Exceptions Bill is a Trojan Horse." And she references the 1925 law that you just mentioned, which a federal court found was no longer in effect in 2023. But she says that if the bill passes, Republicans will get the, quote, best of both worlds. Look like they give a bleep about women's health and lives and expand the state's power to punish abortion funds. Like you're saying, you've heard the concern, pregnant people and friends, neighbors, coworkers, people who love them, who want to help them access out-of-state care. So you have had those discussions with attorneys and abortion rights supporters here in Texas, you're saying, but you still feel confident against that strong criticism in doing something now to help.
I do. And as I said, this is a short-term goal that is something we actually have control over and can make a difference right now. The other issue is absolutely something we have to pay attention to, whether it happened through what this bill would do or what many lawyers believe is already out there with the bills that are currently, the statutes that are currently in place that give access to 1925. Those are things that the courts will work out, and we can't predict what the courts are going to do. We know that once this goes to the Fifth Circuit or the Supreme Court, we don't get protections anyway. Right now, that's what I think we understand. So this is the one thing we have control over. We don't have control over the rest of it. And so I'm making my decision based on talking with many lawyers that have differing viewpoints here and determining that right now, until we figure out as Democrats how to change who is at the Capitol, that we don't have the option to reverse the damage that's been done in terms of allowing women to have access and people who are pregnant to have access to abortion health care. We just simply don't have the numbers, and we're not going to have the numbers if we don't change who turns out to vote. That's ultimately what's got to happen here.
That's right.
There's just no other way to do this. We can't make it happen. And I will tell you that this bill that I signed on to has enough Republicans that will support it. They don't need us. They can go out there and do this and say that they are the ones that are protecting the lives of women. And I believe that, quite frankly, what's happened here is this shows that they were wrong in the first place with what they did. They kept telling us it was clear. It's not clear, and they are now trying to make up for that. So I think our win here is we have said loudly and strongly that this was impacting the lives of Texas women unnecessarily. It was interfering with the doctor-patient relationship. Women were dying. They kept saying, no, it doesn't need to be clarified. Now they're clarifying it. They are admitting that what they did resulted in the deaths of Texas women.
I heard Representative Guerin give an interview saying that this is impacting people that he knows. And I'm sorry that it has to come down to directly impacting somebody that you know. But if that's what it takes and you're here now, everything you just said, Rev. Howard, makes sense. And if we take them at their word that this is to save lives, let's jump on the opportunity. You're in session now. That all makes sense to me.
Well, your point is well made. It's a shame that we have to have it impact us personally before we get it. And, part of the change that's happening now is because of Republican women who are speaking up, especially some powerful, moneyed Republican women. And, okay, I wish they'd talked earlier about this. I wish that we had been able to recognize that this had gone too far earlier. But like you said, this is a political process. We try to find the places where we can get wins, especially as the minority party. And I consider this a win because finally we are having Republicans come to the table and say, yeah, we did go too far. We've got to clarify. And that's what we're doing now.
And circling back to those legal protections we discussed earlier, does this change empower patients in a way that should a doctor neglect treatment out of fear or ignorance, they might have legal recourse?
That's a good question that I don't have an answer to. I think how it empowers them from the limited way that I would understand it as a non-lawyer is that if they understand that they are in a position to have abortion health care and they've gone to a doctor who is not willing to do it, then they can go to another doctor who may understand this law better and be willing to do it. So it empowers them in terms of they do have some options here. Right now, there are few options with only a few physicians who have been willing to go ahead and intervene in these cases. And some have done that, no question. But we know that it's a pervasive problem, a pervasive issue. We had, 111 OB-GYNs sign on to the letter saying it was not clear. Those very same doctors are saying this legislation would allow them to start practicing medicine again with their patients. For women, I think it gives them the choice of going to a provider more so than they might have now. The other part you're asking about, I'm not quite sure about.
Representative Howard, is there anything else that's happening right now at the Capitol regarding abortion and reproductive rights that you're excited and you want our listeners to hear about, or that you're worried and you want our listeners to hear about?
Both. We do have multiple pieces of legislation that multiple Democratic legislators have put forth. I have one on providing exceptions for rape and incest. We have some legislation that will allow for IVF treatments, which have been kind of caught up in the whole when does life begin issue that we have here. We have legislation to allow Planned Parenthood to start practicing here. And that's not to provide abortions, but because of abortions, Planned Parenthood has been prevented from practicing here, even though they're a qualified provider, and we need healthcare providers for women's healthcare. So there's multiple pieces of legislation that, I would say are good pieces that we need to be looking at and supporting. But we do have one, which is to test the water for abortion medications to see if they're in the water. Weird kind of stuff like that. But there's other legislation where they're looking at trying to prevent crossing state lines and the usual stuff that we've had. I will tell you that even though we have a whole lot of people who got elected in the primary, in the Republican primary, who are much further to the right, that I don't think they have the numbers to actually get some of these things accomplished because they have really created a civil war among the Republicans here. And I think that they're going to have a hard time building their own coalition to get some things done. I'm hopeful about that. I think that's what I've seen so far this session. But we'll be looking out for all these bills and don't know what's going to come to the surface or not. This is off subject, but State Affairs had a vote on a bill that was going to change the city of Austin into being a district. And that was so that the state would have control over everything that Austin does. So Austin can't determine their own pathways here. And it died 11-0. That was huge.
I watched the video. It was literally laughed out of committee. Yeah.
So, there are some interesting things happening here, which makes this a very unpredictable session, I would say. But we'll be paying attention, the good, the bad, and the ugly. And the Women's Health Caucus is keeping track of all of these bills. And we're going to be alerting advocates and members, obviously, to when we need to step up and fight these things or push for things.
Glad to hear it. And we'll be following up with you as the session goes on and, staying in touch and let us know what we can do to amplify some of your good work.
That'd be great. Thank you.
Yes, and here at Progress Texas, we are so ready for this fight ahead. So Austin State Rep Donna Howard, we're always grateful for your input and insight, and we appreciate you sharing some time with us during the busy legislative session.
Oh, thank y'all. We're so appreciative here for Progress Texas and all the work that y'all do. Thank you.
Thank you. Here at Progress Texas, we're in the business of countering the conservative disinformation machine that's largely responsible for the election of the corrupt criminal Donald Trump. While that machine is funded by religious right-wing groups and more, we rely mostly on everyday Texans like you who value our hard work and share our belief that a Texas that works for everybody is the Texas that we want to live in. We don't do subscriptions and paywalls because we believe the message of progress is one that everyone should be able to access, learn from, and act upon. If you've become a regular listener, we could use your support, and no amount is too small at progresstexas.org/donate. A very special thanks to our monthly donors, David Griggs, David Sauer, and Doug Beaton, for joining the team lately.
Progress Texas Podcasting Director Chris Mosier here. We understand that the bills we've been discussing on our podcast today fall well short of the goals of many of our allied organizations and advocates. So in addition to Representative Howard's valued insight, we wanted to include statements from other invested parties. Austin Kaplan of the Kaplan Law Firm in Austin helped with the legal representation of Amanda Zurawski and her co-plaintiffs in their well-documented legal case last year. Austin expresses concern that the bills will sow more confusion, saying, quote, Kate Cox's medieval situation, that is the fault of Texas law, captured the world's attention. This law does nothing to change the situations for moms like her in the months and years going forward. It's a messaging trap. The way out is to re-message. It's called the Life of the Mother Act. This does nothing for the life of Mother Kate Cox. She had to flee the state so that she could have another pregnancy and baby. Texas is in the dark ages. This bill does nothing to change it. What are we doing? Is it better than nothing? Yes. Will it fix most of the problems that became a national outcry? No, unquote. A statement from the ACLU of Texas reads in part, quote, this bill is presented as a clarification bill of the current Texas abortion ban. However, it does not actually expand access nor protects physicians from legal risk. This bill only adds more uncertainty, which can delay treatment, and it continues to prioritize fetal survival over the health and life of the patient, unquote. And finally, from Molly Duane at the Center for Reproductive Rights, also central to the Zurawski v. Texas case, who believes that, quote, SB 31 will exacerbate the situation, not alleviate it. First, this change is unnecessary because as a legal matter, the pre-Roe ban is not in effect. Second, this change is unnecessary because the pre-Roe ban's exception should not be interpreted as more narrow than that in the trigger ban. Third, amending the pre-Roe ban is affirmatively harmful to Texans because it undermines the legal arguments that the law is not currently in effect because it has been repealed by implication. Finally, it is logically inconsistent to take both the position that the pre-Roe ban has been repealed by implication and thus there is no risk of the criminalization of pregnant people and or their loved ones in practical support organizations, and also take the position that the exception under the pre-Roe ban needs to be amended. Either the pre-Roe ban is in effect or it's not. It's not, and the legislature should not indicate that it is, unquote. We also want to note that in the Texas House, there are several Democratic lawmakers whom we consider allies who have signed on to HB 44, including John Bryant, Lauren Ashley Simmons, Aaron Zwiener, Jean Wu, Vicki Goodwin, Cheryl Cole, and several others. We appreciate you listening. We'll continue to follow the situation, of course, as we always do. Thanks again for your support, and we'll see you next time.